Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel on the entire internet. First on the docket, a Lori Vallow and Chad Daybell case update. Second, charges in the case of the 2-year-old that was abandoned at the Goodwill in Mississippi. Third, don't interrupt me, I'm playing video games. Fourth, Mom and Dad, you threw away my porn. Fifth, charges in a 20-year-old cold case. You're not going to believe the next one. A horse is sexually assaulted in New Orleans, and our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. Thank you for joining us. If you haven't done so already, we would ask that you please hit that subscribe button, hit that little bell so that you receive notifications when we go live or put up new content. And as always, leave us a comment below. And if something breaks by the time that this video comes out, we will try to go live, whether it's later today or this weekend. But in the Lori Vallow and Chad Daybell matter, for those of you who have been following for the last couple of days, if not, catch the videos that we've put up over the last few days. Now, Lori Vallow's attorney, Mark Means, has filed some pretty accusatory motion saying that the prosecutor in this case, Mr. Wood, should be disqualified. He is engaging in all sorts of misconduct. In fact, it even rises to the level of criminal misconduct. Those are pretty bold allegations, and I'm telling you, if you're going to make those allegations, you better be absolutely certain you are right, or guess what? You are going to have the ethical violations coming your way. So, as I've said before, Mark Means does not particularly impress me at anything he's done in these proceedings thus far. The attorney for Mr. Daybell, doing a lot better. Mr. Pryor, he did really well at the preliminary hearing. I was a little surprised that he joined in the motion to disqualify the prosecutor because it was rather generic. It didn't give a whole lot of specifics as it related to any of the allegations. So I was a little not impressed by that whole maneuver. Needless to say, the prosecutor responded saying, I've done nothing wrong, done nothing inappropriate, and basically, how dare you call me unethical? And by the way, Judge, I'm so positive that this is ridiculous and frivolous. Let's have a hearing immediately. And oh, by the way, we should have a closed door hearing, and we should also seal all the exhibits that were in fact attached to this motion so that it doesn't prejudice everyone receiving a fair trial. Remember, not only do the defendants get a fair trial, the prosecution gets a fair trial as well. So the court, in fact, did that. The court yesterday issued an order stating that everything will be sealed as it relates to the motion to disqualify the prosecutor. Now, so we're probably not going to get to see any orders on that directly, but we'll see if we get a new entry of appearance from a prosecutor, or if nothing happens, we know that the court shot them down. And as the taping of this hearing, nothing has come about. But there was another filing. Both Lori Vallow and Chad Daybell, through their attorneys, filed a motion for a waiver of speedy trial. When do they have to do that? They have to do that when they're requesting a continuance. As we've talked about before, under the speedy trial clock, Idaho, which is very similar to the one we have here in Colorado, from the date that a defendant says not guilty, the state has 6 months from that date to get them to trial. If the case didn't proceed to trial in 6 months, as of no delay from the defense, the case would be dismissed. I'm telling you, never seen a case dismissed on speedy trial, at least not any in my cases. It's very, very rare. And if the defendant asks for a continuance, you have to say that new 6-month period begins anew, because otherwise every defendant would simply just say, I need a continuance, I need a continuance. You make the defendant waive speedy trial so it doesn't prejudice the prosecution. So we know somewhere along the lines, both Lori Vallow and Chad Daybell are going to be asking for a continuance of the trial date. We'll see if the court grants that. Be very curious to see, and I would love to be a fly on the wall at that hearing today, and I would love to see how the judge handles these allegations that were brought forth by Mr. Means. Now, I did have a subscriber, thank you, we'll just refer to them as C, who sent me a transcript as well as a declaration from the attorney Garrett Smith. The attorney Garrett Smith was the attorney that recorded the conversation that is apparently at issue regarding this motion to disqualify. And this attorney Garrett states in this declaration that he is in fact the attorney for Summer Shiflett, which is defendant Lori Vallow's sister. He goes on to state that he has intimate and personal knowledge of the facts set herein, believes them to be true and correct, that attaches a true and correct transcript of the recording of Mrs. Summer Shiflett conducted by prosecutor Robert Wood that occurred on October 1st of 2020, that he was personally present for during the discussion. He states that he recorded the interview in its entirety, and then this is where it gets a little weird. He said that he advised Mr. Wood that I would record the conversation because there's going to be communications between law enforcement. And Arizona is a one-party state. As long as one party knows about it, it's probably okay. I think it's unethical for attorneys to do that. So you have to let everybody know that you're recording so there's no issue whatsoever. Surreptitious recording is a very precarious area. We can get lots of people in trouble. So this attorney this attorney Garrett Smith says that immediately upon realizing the gravity of Mr. Wood's comments during the discussion with my client, I contacted Mr. Means to report unprofessional statements made by Mr. Wood and Mr. Means. Now, this is where it gets good. Then immediately upon realizing the gravity of Mr. Wood's comments during the discussion with his client, I contacted Mr. Means to report unprofessional statements made by Mr. Wood about Mr. Means. Mr. Means asked for a copy of the recording. After receiving advice from the Arizona State Bar and with the consent of my clients, I provided the recording to Mr. Means. Now, this is where it gets good. It says that the attached transcript appears to be not an entire transcript of the recording provided Mr. Means, but the first 18 minutes of said recording. So this is where it gets interesting. So all of a sudden now we had these allegations regarding attempting to influence witnesses, blah, I mean, outrageous conduct by the part of Mr. Wood. And what it turns out to be is that there were what the attorney thought were unprofessional statements regarding Mr. Means. And attached is a transcript. Now understand, I'm taking this at face value, and if it is not true and correct, I'll be the first to correct it. I don't know where this affidavit came from, but there is nothing whatsoever in this transcript that I can see that is unethical conduct in any way. There's no way that anyone is threatening witnesses. He is simply explaining what he is doing. He tells them that he's told both attorneys that there are going to be charges coming down. And remember, this interview took place back in October. And he said, I'm trying to make a case for murder, but we're not sure we're going to be able to do that. So this is the part that probably just irked Mr. Means in this conversation. Mr. Wood states, quote, I said this to somebody the other day. Who knows your sister is our goal is. Sometimes you get murder and all you have is that murder and you just have to run out and charge it, and then you kind of put it all together. We were able to put them in jail with a high bail on these low charges and put together a case. Now our goal is to have such a strong case that when she has competent counsel, I don't know if you know this, her attorney has never handled a felony before. Ms. Summer responds, Prosecutor Woods, he's never done any meaningful criminal work at all, and he doesn't know what he's doing. He's a nice guy. Ms. Summer, yeah, I've met him. Other than that, when he's lying about me, but he doesn't know what he's doing, and once we file further charges, she will be appointed counsel who will know what they are doing. And our goal is to put together such a case that they're smart enough to say, gonna be better to talk. Summer. So that's where apparently Mr. Means got a little ruffled around the collar, so to speak. Mr. Woods then goes on and even says, hey, I get it. Everyone's entitled to defense. I've done defense work before he was a prosecutor, done it for 5 years. He understands that there's good people that make mistakes. We'll put this transcript up at scottreisch.com so you can read it yourself. And I'm telling you, there's nothing inappropriate. Maybe he should have kept his comments about the other counsel to himself, but let's face it, he's saying his opinion. And frankly, it's based upon facts. If Mr. Means has never done a felony trial, jumping in on a serious case where murder charges could be coming down the pike real darn soon, guess what? You may want to have somebody that has done a few criminal cases. But hey, what do I know? I'm just a practicing criminal defense attorney for 25 years. We'll see how things shake out. I think when the orders come out, Mr. Wood remains on the case. Mr. Means is going to look like a fool. And if I'm wrong, I will be the first to say it, but I don't think that I'm going to. So let's wait and see. And hopefully we'll have a new update by the end of the day or over the weekend. But as of right now, nothing regarding the closed hearing that took place today that started at 10 a.m. As you may recall, we brought you a story earlier in the week where a 2-year-old child was abandoned at a Goodwill donation center in Mississippi. Well, guess what? Now, 2 people are facing federal charges in the case of this 2-year-old boy that was abandoned at a Mississippi Goodwill. Jeremy Fitzgerald and Terliska Turner of Memphis, Tennessee, had been charged with kidnapping the child. And this is according to the United States Attorney's Office in the Western Tennessee District. The boy was dropped off Monday at South Haven, Mississippi Goodwill store with nothing but a bag of clothes and a note. Police say a bystander had called to report that a man wearing a black jogging pants and a cowboy hat had left the child there. Now, according to the criminal complaint, Fitzgerald offered to have Turner, who was posing as his sister, babysit the boy while Fitzgerald and the child's mother went to Nashville on Sunday. Fitzgerald then demanded that the mother work for him as a prostitute. When she refused, he left her in Nashville and did not answer her repeated calls. Fitzgerald then spoke to the child's aunt, demanding money for the child's return. Bad move. Turner was aware of the demand for money in exchange for the child, according to the complaint. On Monday morning, Fitzgerald, Turner, and an unknown person drove the child across state line to South Haven, Mississippi, according to the complaint. They stopped at a gas station, and while Turner went inside, Fitzgerald took the child to a nearby Goodwill store and left him there. Now, that's how the case became federal. There was a crossing of state lines. When there is a crime involving interstate commerce, i.e. crossing state lines, then the feds will have jurisdiction. Or if it takes place on exclusive federal land, then the feds could have jurisdiction. Here it was a crossing of the state lines. If it had all been done in one state, intrastate, then the state would have exclusive jurisdiction in this particular case. Now, the possible charges here for the people involved in this is sentences up to 20 years to life in federal prison, plus a 5-year mandatory period of parole and a $250,000 fine. You think this guy, but let's face it, if he's out there trying to prostitute young women, probably not exactly the most ingenious guy in the world. You think he'd like to have all that back and maybe just drive the woman back, get her child, and send her on her way. Sometimes people, when they make decisions on emotion, make some very poor decisions, right? As emotions go up, the good decision skills go down, right? Emotions go down, good decisions go up. That's why you hire attorneys, to remove yourself from the emotion of the battle and get good advice. Now, next on the docket, don't interrupt me. I'm playing my video games. This is what the world has come to. Now, I have said this jokingly. You know, this is why people need to get CrimeTalkSearch.com. If you go to CrimeTalkSearch.com, you can find out if somebody is, a 40-year-old man living in somebody's basement, because we got two stories here for you back to back. Well, first, a Michigan man is dead and his wife seriously injured after the woman's son allegedly attacked the couple because they asked him to turn off, that's right, his video game. According to Meredith Digital, 29-year-old Christopher McKinney is facing multiple charges after the December 11th attack, which are expected to be upgraded as his stepfather died 4 days after the incident. So just yesterday, a neighbor reportedly contacted the police on December 11th after seeing McKinney outside his Madison Heights home covered in blood. Responding officers found his 66-year-old mother and 71-year-old stepfather, who have yet to be identified, with assault injuries and stab wounds. Officers also found McKinney outside his home with blood all over him. The suspect allegedly spat at the police officers and assaulted a fire lieutenant who was attempting to perform first aid. According to the report, a subsequent investigation found that McKinney's mother and stepfather had asked him to stop playing video games in their bedroom so they could go to sleep. In response, McKinney allegedly attacked them both, punching his mother in the face and hitting the stepfather. The stepfather then goes to the kitchen to grab a knife in order to defend himself, but McKinney wrestles it away from him and then stabs the stepfather repeatedly. Now Mr. McKinney is in custody on a $510,000 bond, and he is facing very serious charges. As we stated, his stepfather is now deceased. One question here, ladies and gentlemen. What the hell is a 29-year-old doing living at home? I just don't get it. I just do not get it. But wait, there's more. Meet David Working. This guy was living with his parents because he moved in with them because he got a divorce. Now, I understand things happen in life. If you got to go live with your parents for a day or two, at most a couple of weeks. But needless to say, things didn't go well. Mr. Working had been there over a year. The parents found his collection of pornography, which included some 1,600 titles, as well as DVD, VHS tapes, and sex toys. Well, the parents threw them out, basically claiming that this was an addiction, and they would have done the exact same thing if they had found, let's say, drugs or alcohol. Well, David, who estimated the cost of his pornography collection to be quite expensive, ultimately sued his parents because he had them make admissions in emails that they had in fact destroyed the property. And when you destroy somebody's property without permission, although in this case they didn't charge it as a crime, he sued them civilly, and now they have to pay some $75,000. Because why? David, the man living in the basement of his parents, out of the graciousness of their hearts and looking out for their son, and thought they were looking out for their son, he valued his pornography collection at $25,000, or at least his attorney did. And they're also seeking treble damages, so 3 times the actual cost of the property. That's right, $75,000 from your parents, who took you in when you basically would be homeless, and you couldn't have taken your porn and your toys with you. David Working, you get the Best Son Award. I'm telling you, I've seen lots of things. This takes the case. Just a little rule of thumb, ladies and gentlemen. Grown men don't live in their parents' basement, at least not more than a day or two. What do they say? House guests and fish start to smell after 3 days. Come on, pull yourself together and go get your own place, please. Otherwise, you wind up suing your parents for $75,000 for destroying your porn collection. Get for real. And that, ladies and gentlemen, is why everyone should go to CrimeTalkSearch.com and sign up today. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report that's going to give you this person's social media information. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, charges on a 20-year-old cold case. And wait till you hear the reason why. Berkeley Calvin Curtis Jr., who's now 45, was charged Tuesday with the second-degree murder in connection with the death of Rebecca Pena from 20 years ago. This case has obviously bothered police, it's bothered the parents, and the police believe that they have the right man. Rebecca was working as an extra on a movie set at the time where she was returning home rather late at night. Make a long story short, she was found in a river, stuffed in her suitcase, and in that suitcase was a weight, like a barbell weight. And when the boaters found the body, obviously the police got involved, and the weight inside was a 25-pound weider, W-E-I-D-E-R, weightlifting plate to help obviously keep the suitcase down in the water. An autopsy ultimately could not determine how she died, but prior to her disappearance, Ms. Pena had a protection order against Curtis. And according to her father, she was afraid of Curtis, a physician's assistant. Now, the police, some 20 years ago, served a search warrant on Curtis's home and found a weightlifting bench, barbell, and a 25-pound weight that matched the plate found that was in the suitcase. But during the initial investigation, Curtis had a girlfriend, and that girlfriend claimed that he was at home with her that night in their Miami apartment and had left for only about 20 minutes to go to the store. Well, guess what? She was interviewed again in 2014, and she changed her story. She told the police that he was actually gone for several hours. And when she changed her story, the alibi crumbled, which has ultimately led to the charges. Now, it's not exactly clear why, if she changed her story in 2014, that it's now 2020 and filing of charges are just taking place. Now, the attorney that originally handled this case back in 2001 for Mr. Curtis is going to be representing him again, and says obviously that there is no evidence whatsoever, no direct evidence or eyewitnesses or confession against his client. And these weights that they think they found, guess what? There's probably a million of them, which I'm sure the police have considered, and I'm sure they've tried to match it to the weights that were seized at his residence some 20 years ago. Obviously, Mr. Curtis is given the presumption of innocence, but we'll continue to follow that case as well. Next on the docket, a horse is a victim of a sexual assault. This goes into the category of you simply cannot make this stuff up. Well, the New Orleans Police Department is searching for a man who committed unnatural sex acts with not one, but two horses on Tuesday. The alleged animal abuse happened around 2:15 a.m. at the stables on Fillmore Avenue in New Orleans City Park. The New Orleans Police Department is searching for this man. Take a look at him. All right, someone's got to know this guy. Is searching for this man who committed, allegedly, the unnatural sex acts with the horses. He is described as obviously a male wearing a striped shirt with a distinctive tattoo on his right arm. He apparently entered a cluster of stables in the 100 block of Fillmore Avenue and committed these unnatural sex acts with two horses. The scary thing is that even police horses aren't safe, because one of the horses actually belonged to the Orleans Parish Sheriff's Police Department. The suspect is wanted on felony charges of sexual abuse of an animal which carries a maximum sentence of 5 years in prison. And if anybody knows who this is, they should contact the Greater New Orleans Police Department at 504-822-1111. Now, let's face it, people can do what they want, but animals, horses, I mean, that's getting real close up there to people doing bad things to children, and it's just gross, right? I mean, come on, unidentified man. Clearly, you could have done something other than allegedly sexual assault a horse. Good God. Next on the docket, our dumb criminal contestant of the day, and then we'll recap our dumb criminal contestants who are here vying for the title of Dumb Criminal Contestant of the Week, and to find out who will be the recipient of a Crime Talk mug. Well, please meet an Oklahoma man by the name of James Watts. Now, James Watts thought it'd be real cute to have his 2-year-old daughter take a picture that he could put on Snapchat. That's right, partaking of some Smirnoff Ice wine coolers. And in the video, Watts states in text, quote, "My baby gon' be drunk," end quote, along with an emoji with a hand on its face. Watts also wrote, quote, "She liking it a little too much," end quote. Describing the video, an investigator notes that Watts allowed the victim to take a drink, then he takes a sip and hands it back to her so that she can have another sip of the alcoholic beverage. Now, the mother of the child was the one who actually reported Mr. Watts to the police. Now, Mr. Watts, you are a dumb criminal contestant of the day for a couple of reasons. First, well, let's face it, we've all let the children have a sip of something at the dinner table, perhaps a glass of wine, maybe a sip of beer when they're younger and under the age of 18. But 2 years old, really? Not a smart decision. And then, Mr. Watts, if you ever watched Crime Talk, you would know by now you don't put your crime up on video for the world to see, even if it is Snapchat, right? The one that's supposed to disappear. Let me tell you, even though you think it's gone, there's a big computer at Snapchat that has those videos. I've seen it in cases where the police have immediately sent a request to Snapchat and they're able to retrieve those videos. So everyone who thinks they're getting away with something because it disappears, it doesn't disappear. So Mr. Watts, you are a dumb criminal contestant of the day. Now let's recap the contestants throughout the week. First, we have our unidentified man who called the police regarding a disturbance, and unfortunately he had warrants and went to jail. Next, on Tuesday, we had Caleb Kleiss, the guy that was drunk and apparently a little paranoid and took the AR-15 out of the back seat, put it on his lap, and then maybe pointed it out the window at other individuals. You can't own a firearm or possess a firearm when you're in fact intoxicated. Then we had Jeffrey Randall, who likes to beat up at-risk adults when they don't agree with him that Boston has the best sports teams ever. Yesterday we had Alice Sweet. He was the chainsaw robber up in the state of Maine. And let's not forget Mr. Watts from the great state of Oklahoma, letting his 2-year-old partake of a little Smirnoff Ice cooler and then putting it on Snapchat. So, well, apparently the baby mama can see it, and guess what? She didn't approve. That's all we have for you today on Crime Talk. I want to thank everyone for watching. We'll have a recap for Saturday. You can also go to Instagram, Facebook, and Twitter as well if you'd like to check us out. Go to ScottReisch.com. We'll put the transcript up as well as the affidavit of Mr. Smith. You all decide if you think there's something inappropriate whatsoever in that transcript. Don't think there is. And if there's an update, we'll bring it to you live. Have a wonderful day. Thanks for watching, and we'll see you next time on Crime Talk.